Hello, everyone. Yes, it's the Professor Buzzkill History Podcast, busting myths and taking names. And very, very fortunately for all of us, we have one of the most important historians in the United States right now, Dr. Orville Vernon Burton, on the line via the internets, who is the Judge Matthew J. Perry Jr., Distinguished Professor of History at Clemson University. And he's here to talk to us about a very, very important book that all of you should read called Justice Deferred, Race and the Supreme Court. Dr. Burton, thanks so much for coming on the show.
Thank you for having me.
You've co-written this book with a civil rights lawyer named Armand Durfner, and it really is one of the most comprehensive, yet very accessible and readable histories of this issue of civil rights and the Supreme Court. I just wonder what it was like, before we started getting to the questions, what it was like working with an actual lawyer and a historian together, trying to put together one comprehensive overview of race in the Supreme Court.
Well, it was fun and challenging, and this book really began 40 years ago when attorneys realized they needed to have historians to make their case when the Supreme Court required that you had to show intent and purpose, not just the effect of laws. So, as Rick says in Casablanca, that was the beginning of a beautiful friendship.
Right.
So it was fun. We had discussed the issues forever, but it's very different. And I truly believe that no historian could have written this book. And I have checked both with Armand and several law schools where we've spoken, and the attorneys and law professors say the same thing, that no law professor could write. It really is a book written by a historian and an attorney. And thanks to my wife, Georgianne, we sort of have one accessible voice there for people to be able to read it. And it is the story of race in America through the lens of the Supreme Court.
Yes, and Professor, one of the things that I have found so eye-opening, distressing, and has always changed my impressions of history as I've grown up is when I was born in the early 60s, and when I was a kid, to us, the Supreme Court was the point at which things got fixed, especially civil rights things. So you would hear about cases, bad things happening in Little Rock and other places, bubbling up through the system, and the Supreme Court would fix them. And I think even my parents, when I was young, would say, well, that's how it works. They're these learned elders, and they sort of fix everything. And I often think of the Dick Gregory, the famous comedian statement where he said something like, for hundreds of years we've had men in white robes taking away our rights, and now men in black robes are giving them back. And it's shocking to me to when you actually see this down on paper. You write in the introduction that African slavery and Jim Crow prevailed for 300 years, and they've only gone for just over 50 years. So if we count a generation as 25 years, then American history has consisted of 12 generations of white supremacy and barely 2 generations of trying to overcome it. And when you grow up as a young person, when you were young during the part where they were trying to overcome it, it seems like it was always that way. But we know now, of course, the history isn't like that.
No, you're exactly right. And it was something that, we weren't really aware of so much easier. The book actually begins with Native American, but you have the really first case on African Americans goes pretty well, the Amistad. And then you start going backwards, and except for Reconstruction, a brief period, then you set in Jim Crow. And it really is. So one of the things I would ask anyone to do when they say, including Supreme Court justices who decide that our race relation problems are over or they are solving themselves, ask them to count to 12 and then count to 2 and then observe the difference, because we have had 12 generations literally of the law supporting and mandating racial discrimination. And this, continues, of course, right through white suburbs, white schools today, black schools today, mortgages and government housing, all of these things. The laws have reinforced that. And we've only had that brief period, really, beginning with Charles Evan Hughes and then the Warren Court. And like you, I grew up with the Warren Court. In fact, I did a little history for Illinois on legal history and the Constitution. I said, everybody loves the Supreme Court and the Constitution.
Yeah.
But things are changing. And unfortunately, one of the things we learn is things can go backwards as well.
Yes, well, they certainly can go backwards, and we seem to be in the middle of that right now. Do you mind telling us a little bit about how the book started? Well, about these early cases. You know, I don't think any of my students, for instance, think about civil rights cases really until they start thinking about, as you say, the Warren Court and things like that. But your book goes all the way back to, as you say, the very, very beginning. And I just wonder, what is the blend like of African American civil rights cases and Native American civil rights cases? Is there a concept of these things being civil rights cases way back when in the late 18th, early 19th century or anything like that?
Well, the earlier ones were more about slavery and race. First of all historians will tell you today there's no such thing as race. There's no gene that determines race. But here's what the interesting thing is for us in American history is, of course, we created a legal construct of race.
Right.
Which is really sort of fascinating when you think about it and how that all comes about. The early cases, of course, dealt with slavery and enslavement.
Right.
And of course, the most famous is Dred Scott. And there again, you know, the court did not have to rule as it did. It went beyond, as is happening today, if you want to see parallels, what the case was about, to then argue that African Americans have no rights and sort of ignore it. And one of the things that I learned that was very interesting, and it's a good lesson for us today when we get a little discouraged, is the dissents. You just assume that, well, at that time, the judges didn't know any better. But if you read the dissents, say in Dred Scott, or even in the fugitive slave law cases, what you will discover is there were others who were pointing out the alternatives, that there were alternatives. Judges are always making choices. So I think, like the great Justice Harlan, the great dissenter, we're going to see Sonia Sotomayor's dissents become more important, in fact, than maybe the rulings that Judge Alito or others or Clarence Thomas have done. And they're important because they point out that you have these alternatives. So judges always have been able to rule with a law as broad as they want to or as narrow. And one of the most interesting things you see going on today, I'm sorry I'm jumping forward.
No, it's okay. That's okay.
They are
like that, actually.
The First and Second Amendment as broad as it can be, and reading the 13th, 14th, and 15th Amendment as narrow as it can be.
Right.
I'm all right with someone being an originalist, but the 13th, 14th, and 15th Amendment changed the Constitution of the United States. You know, Lincoln said if he would be remembered for anything, it was Emancipation Proclamation. But I think instead it is that he took, now he's dead, but even before the 13th Amendment is actually ratified, but, you know, he pushed it. And then the 14th and 15th, Grant and others are saying this is Lincoln's legacy. So I say Lincoln took what was basically our mission statement, something he loved, the Declaration of Independence, and put it into our rule book, the Constitution, and it changed it. Eric Foner has recently called it a second founding, which parallels what we argue in this book. So when people say they're an originalist, I think they need to read the 13th and 14th and 15th Amendment the same as they do the first and the second. But yes, this whole idea of race, do you want me to elaborate on that?
Yes, please, yes.
You know, I think the best example is this. You know, the Naturalization Act of 1790 actually limited naturalization to only, and I hope I got this quote right, free white persons. And of course, that's amended in 1870 to include people of African descent in this period of real idealism that changes the Constitution and things. But the Naturalization Act is amended time and time again. So literally in 1922, after one of these amendments, a Mr. Ozawa, who was born in Japan, but had been a long-time resident in the United States, thought that now the naturalization law had been worded in such a way that the requirement of being white no longer applied to people wanting to be naturalized citizens. So the case went all the way to the Supreme Court, and the Supreme Court agreed that the wording might be interpreted that way, but that clearly the meaning and purpose of the law was such that white remained a requirement. But the court, again, like in Dred Scott, wasn't satisfied with that. So they went on to say that white could not merely be color because some white people had darker skin than non-white people. So
right.
The justice decided that white meant Caucasian. Mr. Osama was not Caucasian and was not eligible to apply to U.S. citizenship. So the very next year, Mr. Thine, whose ancestry went all the way back to the Caucasus Mountains, that region of Europe, which meant he literally was a Caucasian, applied, saying that he was Caucasian, but he's from India and had brown skin. The court tried for a while to provide some kind of rationale, and then in 1923, just 1 year after saying it was Caucasian that mattered, it finally decided that Caucasian really meant white. So I like to point out, and this is in the book, that the Virginia judge who originally convicted Richard and Mildred Loving of black and whites being married and illegal in Virginia said, Almighty God created the races, white, black, yellow, Malay, and red, and he placed them on separate continents. Therefore, he ruled that God did not intend for the races to mix. And so literally the Supreme Court has dealt with all of these different groups, and that's what we did in Justice Deferred as well. Those people, there's no such thing as race, but looking at the Latinx, Japanese internment, people who were not allowed to vote, or naturalization is a good example as well, that were discriminated against. But most of the case law, most of it, though it begins, of course, with the Native American and the Cherokee removal and rulings there, but most of the law dealt with African Americans because that's where the race law was. And then when the NAACP comes on board and starts moving toward what we think of as the civil rights movement, is where most of the case law itself is, and it applies to other groups. And it changes over time. That's the other thing. The law itself is almost a moving target.
Right. And judges' opinions can then become a moving target because as they're set into law or precedent, then they themselves become judged again over time.
Yes, right. And that's an interesting concept, precedent. We just had several judges who claimed they would not, rule against precedent, accept precedent, but we now have a new thing going on in the court that's very different. And yet, if you look at Brown v. Board and how we got there, and this sort of interesting history of the sort of, what would you say, maybe the genealogy of cases, when Plessy B Ferguson's the case everyone studies.
And that's in the 1850s.
1896.
1896, yeah.
Yeah, 1896, which sets in Jim Crow, separate but equal, supposedly. Of course, we never had equals, just as we've never had integration. But 20 years earlier, in 1872, the court had ruled just the opposite on a railroad case for a Ms. Brown, and said that you could not have separate but equal, that you had to allow African Americans to sit in the first class cars with whites. So it's not the first time that we break precedents. It's unfortunately one of the things we learned, except for this period that you and I grew up with, that judges seem to find ways to rule against minorities over time. Ever which way the law changes.
They find new ways.
Whether they're saying it takes effect, you have to prove effect. Well, if you prove effect, they say no, you have to prove intent. You prove intent, they say no, you have to prove effect. So finding ways to rule. And it's really sort of, as opposed to seeing the court as I always had, and apparently you had too, as our sort of where we can expect equal rights under the law.
Right.
That most of the history has been pretty distressing when you look at least how they have dealt with race, except for certain brief periods in the overall arch of American history.
Now, and you talk about it as, there are these massive stretches of time, right? There's right up until the 13th Amendment is this whole stretch of time where things seem to get more and more ossified. And then there's a brief period of at least new constitutional innovation. And then again, there's this reaction. So we can't say to our students on the one hand, we say to our students on the one hand, well, it's not really a sort of Whiggish interpretation of a gradual increasing of rights over progressively over time, and it's not a pendulum either, because sometimes it swings drastically in the other way, and further in the one way than the other. I just wonder, historically, looking over the whole stretch of the court, whether there's a way we can sort of try to understand how it works as an institution, how it flows as an institution. Is it an organic body, or is that impossible because of what you talk about, the time and chance of justices happen to die at certain times, et cetera, et cetera, et cetera?
Yeah. And I think contingency does play a large part. But I like to remind people, remember, Hamilton says it's going to be the weakest part of the government.
Yeah.
And how it's developed over time. Judicial review, of course, is created by John Marshall.
Yeah.
It's not even in the Constitution. And this whole debate on the number of justices, I think we started with 3, it's been 5, it's gone different numbers over time. And finally, we've got to 9. During Reconstruction, there was a period when they did not want Andrew Johnson as president to get an appointment, so they wouldn't fill a replacement. But the overall, I think we have to think of it in terms of the 3 branches of government. And it's always been pretty much partisan. Yeah. So I think people have to remember that we are not in a parliamentarian form of government. What is different is that it is a winner-take-all for the presidency.
Right.
You may not like a woman wears pantsuits, but you might want to think about what that means for the judicial system if you think you don't want to vote for someone over another, because we basically have these 2 parties, and it's always been and it's become even more so the sort of vetting process, so that you don't have the surprises that we sometimes had from some judges when they were appointed and things. It's a lifetime appointment, not only for the Supreme Court, but for the federal judges. And it's at that level. We don't do that much with it because that's another book completely. But those judges are making the rules, in fact, that probably affect people at the local level even more than by the time it reaches Supreme Court. And there's that process that goes through there. So what's always happened before, at least in the more progressive period that you and I have thought about, is that Congress could reach a bipartisan agreement, at least on fairness, it seemed, or access to the vote, or equality.
Right.
There was always, for a long time, particularly when the African-American population was really concentrated in what we think of the American South, but you would have Northern Democrats and Republicans supporting legislation. So the big crisis that got me involved in 1980, John Lewis, my co-author, the great civil rights attorney Armin Durfner, was in charge of getting a renewal of the Voting Rights Act. Congress stood up together, and even though the Supreme Court has said that you had to prove intent and purpose, which is very difficult to do, that effect would be enough, and then laid out guidelines of how to do it. What is most disturbing today is we don't have that bipartisanship, even on these major issues, or very seldom, though clearly both President Obama and President Biden really strove and thought that they could do bipartisan work with Congress. It's been very difficult and become extraordinarily difficult, as we could see with the, of course, nomination of Merrick Garland for the Supreme Court, and how that was blocked. That's pretty well unprecedented for that length of time, showing just how political the process has become for the judges who are vetted for the Supreme Court. And they're so carefully vetted now.
Yeah.
One of the things that's most disturbing is, though, that people in testimony would say they would recognize precedent, sort of as in Roe versus Wade,
right,
and then to rule the other way. And that's hard to explain away.
Well, this is a good place for us, Professor, to take a sponsorship break. So we'll tell our listeners we'll be back in a moment. We're back, Buzzkillers, with Dr. Orville Vernon Burton on the Professor Buzzkill History Podcast, talking about this extremely new new book called Justice, Deferred, Race, and the Supreme Court. Professor, just before we left, we were talking about how we were talking in sort of a larger ways about how race and the Supreme Court have worked, or the relationship that race has had with the Supreme Court and the Supreme Court has had with race. Do you mind, in the second half, taking us through sort of chronologically how that developed? I mean, one of the things people forget about is there are these sort of staging posts of not only landmark cases, but also generational shifts one way or another in the court's history and its attitudes towards race. So if we could start in the early period of the Republic, what kind of cases relating to race come before the court?
Well, the first one in the book sort of interestingly begins with a case with indigenous population and sort of ends with one, the adoption case fairly recently about Native rights. And of course, it's different. That's one of the most, it's about Native Americans wanting sovereignty,
right,
dealt with as a sovereign nation. So the first ones, of course, allow for the removal of the what we call the five civilized tribes out of the South, and what we think of dramatically as the Trail of Tears, which is more complicated than often the way we have time in a survey to talk about it. But the first really major case was interesting, the Amistad, which worked in favor, even though the federal government, the presidents, and really wanted a different rule, and it ruled in favor of those people who had what we would think of a mutiny and brought their ship into the United States by mistake, thinking they were trying to get back to Africa. And then their suit, it goes against the Spanish government. And of course, this is a case that has been Steven Spielberg has made a movie of. And John Quincy Adams, who had been a former president, old man, eloquent, makes the argument. And the ruling is in favor of these Africans there. But then you get into particularly the Prigg case, which is about people and part of the fugitive slave law. And that could have easily gone the other way. And the dissents show how easily it could have been. But the court, again, probably for political influences, and this was a case that was sort of contrived to get a ruling on people who were free or thought they were free in the North, who had been enslaved, and exactly what the limits of enslavement was, went the wrong way. And then the terrible, of course, is Dred Scott, probably seen as the most infamous case in the United States. And there again, you see the politics involved. And one of the most interesting things about that, and I don't believe this is in the book every time, but it just resonates. I'm sorry to jump on you again, but it resonates with me. And of course, the case is one of the things we try to do. The case is not just Dred Scott, it's Dred and Harriet Scott.
Yes, that's always forgotten.
And the most interesting thing is to find out that once again, precedent would have ruled that Dred Scott and Harriet Scott would have been considered free. In fact, even in South Carolina and Mississippi, not just Missouri, they would have been considered free. That was the law if they had gone that time. And then the judge in the lower court says that would be the case, but times are not as they were.
Yeah.
And I just found it resonating so strongly that when I read on the case that really gutted the Voting Rights Act, and I have argued the Voting Rights Act is so important to the United States. In fact, my specialty is American South.
Yeah.
And I say two things have changed the American South. Air conditioning, the Voting Rights Act. And the great irony is for us as historians is that people understand how air conditioning works better than they do the Voting Rights Act or our legal system.
Yeah.
because we believe in STEM education. But for democracy, you need to also have what we think of as history, civics, government, and we just have not had that emphasis. So when Judge Roberts ruled that Section 5 was no longer effective, really Section 4, which is a part of the Voting Rights Act that picks out by a formula which jurisdictions, election jurisdictions, which meant most of the American South, had to have every decision pre-cleared when it came to voting.
Right.
What does he say? Things are not as they used to be, almost a reflection of Dred Scott.
It's amazing.
And then it is. And then in 1981, I'm involved in a case now on Georgia for a group of attorneys for Stacey Abrams for SB 202, which is the law that most people know about, that, oh, you can't get drinking water or food when you stand in line, but it's much more complex than that. And it really is.
Right, standing in line to vote. Yeah.
On voting. So when Judge Alito then, and of course, Judge Roberts said, well, we don't have to worry about Section 5 because you still got Section 2. Then Judge Alito really went after Section 2 in 2021 decision, which is, we actually have it in a footnote in the book, and it's very dangerous as a historian because you don't want to predict what's going to happen.
No.
Sort of saw it coming, and I don't claim to be a prophet. Unfortunately, we were right on this one. But what does Judge Alito says? Today is not like 1982, and 1982 is significant because that was the big renewal of the Voting Rights Act. And in fact, the attorneys asked me to look at that issue in Georgia and to see, compare today in 1982. And I said, well, actually, Judge Alito is right. It's not like 1982. It is much worse. It's like 1898 and Mississippi versus Williams. People all in 1982 accepted everybody ought to have the right to vote. They worked in ways to dilute the vote. We're most familiar with gerrymandering, but, literally moving districts around or making it more difficult. But we are back now in the United States trying to find ways to deny the people the vote.
Yeah.
At any rate, that for me, for Dred Scott, is just how the judges each time say that things are not as they used to be. And for historians, that change over time is interesting how we rationalize. And that's why the 12 generations we talked about earlier is so important, I think, for people to understand. But again, when we think about the partisanship, we discussed this little deal that was going on. Buchanan looks like this seer. The idea as president is that this is going to, for Judge Tony and others, that this will end the problem of the crisis we're in that becomes a civil war. It's not there yet, of course, but this will have a decision. And so he says, I will abide by this decision, whatever it is, as if he doesn't know. But as president, he is actually lobbying on this and knows where it's going with the Supreme Court, trying to get northern justices from the north to support it because he doesn't want to be seen as just a southern decision by the court. So we have this little sort of political intrigue that goes on there as well. And of course, as opposed to solving the problem, it becomes extraordinarily leading to the war. And the other thing to do is to look at those dissents. For instance, Judge Tony says that blacks have never had any rights. Well, even in North Carolina was one of the states where free African Americans voted on the same basis of requirements as whites did, and they made a difference in elections. I just did a court case in North Carolina on felonies, and now felons have their rights restored and they can vote. But that's when I discovered that the elections, the reason that they disfranchised the free African Americans in the 1830s in North Carolina who voted was because they were making a difference in the elections of the candidates who were winning. So even that, the history was wrong and bad. The use of history was wrong. And the interesting thing is the dissenters say that. So there's no excuse for him not to have known it and to know what he was saying. That's one of the things I have learned by looking at these dissents, when you think, well, oh, that was just time and people didn't know any better and they felt differently. But to understand there was always that alternative, and that's the importance of those dissents. But the most interesting thing to me is, as I said, you have the Civil War and this change. Now, it's hard for some justices to get their heads around this shift that Congress now has the right to enforce things. Everything before the Civil Rights and Reconstruction Amendments said that the states had the rights. They weren't enumerated. But now the 13th, beginning with it, the 14th and the 15th Amendment all say that Congress can enforce these rights, for such that states cannot treat people differently. And one of the themes of the book that I'm most proud of is the power of the 13th Amendment. During those Reconstruction years, the 13th Amendment is interpreted very powerfully. And one of those interpretations that becomes precedent is that you cannot, the 13th Amendment ends the badges of slavery. It's not just freeing people, but that the badges of slavery. And think about what the badges of slavery are today. You go into a McDonald's and it might be a white person at the cash register and flipping the burgers, or in fact, African Americans or others. So that 13th Amendment is a powerful, and why that becomes so important is though the 14th gave citizenship to African Americans, which was directly related to the Dred Scott decision. The law still on the books, of course, was Dred Scott, that African American had no rights. So the 14th Amendment, and then the 15th for the vote. And you shouldn't have needed even those with the 13th Amendment. And a little aside is sort of interesting. When Lincoln is assassinated, his cabinet is evenly divided on whether they will require the former Confederate states to enfranchise African Americans. Of course, Andrew Johnson takes over. The first state he brings in is North Carolina, and without even consulting the cabinet, he puts in a grandfather clause as part of the North Carolina, which says that you had to vote in 1860 to be able to vote. And that changed. And Charles Sumner has a great letter, and I think I quote it in the book, where he says the disaster of what has happened here. But African Americans anticipated, and others did, that the right was coming to vote. But you shouldn't have even needed that with the 13th, 14th. But why that 13th Amendment is so powerful, what has happened to the 14th Amendment? All of we historians know it was written explicitly for African Americans to be citizens, and yet 80% of all cases are corporations now.
That's amazing.
And it's been gutted. And, the 14th Amendment that is used for whites to challenge what we think of as affirmative action, as I point out in the book, it's the second affirmative action. Whites had affirmative actions for extraordinary long period of time. Nobody was upset. But it's also the very same things in which people are challenging voting rights laws, which have allowed African Americans to finally have an opportunity to elect candidates of their choice, the 14th Amendment. And now, with what's happened with Judge Roberts and Judge Alito's rulings, which is the Voting Rights Act, enforcement of the 15th Amendment, it really is important, I think, to understand that the 13th Amendment is still there very powerfully to get rid of those badges and incidents of slavery. And it was renewed in the 1980s during the Burger Court, and again used powerfully that way. So you have this period of time, and then you begin, of course, with the Slaughterhouse case, the Cruikshank case, which I think people don't understand how important it is. And I do want to say this book is not case law. That's what it sounded like.
But it is.
And I'm making it sound like it's a case law book, and it is not. Those cases are there to explain it, but it's about the people. Themselves. So, and of course, Slaughterhouse is perfectly a good example of how that happened. They even say if this had been about black people, they would not have ruled as they did to begin to undermine the 14th Amendment thing, but it's white former Confederate butchers, and their attorney is someone who'd been on the Supreme Court, went to the Confederacy, hates the Union, so the decision is sort of a minor. But then it's even as today, as I try to point out in court to judges, it's just one little change. And that's just one little change, like Judge Roberts said about Shelby. But you begin to have this cumulative effect.
Yes.
Each one of them. So then suddenly in the 1890s, when one party is completely in power in the former Confederacy, that they put in complete segregation and completely stop. Well, I say they never completely, but make it pretty much disfranchise the African American population. And one of the things people don't understand about Colfax, which is so powerful and just something I discovered after years of research and reconstruction and doing this book, when Colfax said that you could murder people, as in the Colfax massacre,
right,
and unless it was state action involved, that is, that these were the state doing it, that the federal courts could not do anything. It would be the state courts where you had all white juries that said no, of course, that they aren't guilty. That came down. And then something I had studied, my first book was on a community study of Edgefield, South Carolina. There's a famous, infamous, I say, horrible, called the Hamburg Massacre.
Right.
The people who led that, one became a state senator. There were two generals from the former Confederacy, and one of them was there and directed. They were attorneys. And that ruling had just come down when they massacred African Americans again. People knew that they could get away with it because of that Supreme Court ruling. Now, I don't think the Supreme Court understood that's what they were doing. It's interesting, too. We analyzed a lot on that case to show just how wrong they were in that decision-making process and things. And then you have the other cases where you have all white juries, things like that, that are all allowed until finally you have complete disfranchisement. And then one of the more interesting things to me was Booker T. Washington, who, as I went to graduate school at Princeton, it was Booker T., the accommodationist, versus the great W. Du Bois, who I still love, and is part of the NACP story in this book. But what you discover is Booker T. Washington is actually using money and things and his influence to support not only cases that become one of the more famous is debt peonage, but he's also even fighting for voting rights and supporting it. So there's a different Booker T. Washington than we as historians and the general public have seen over time. And he uses that influence to get people to give money to support it. We forget, and even today, why particularly Section 5 of the Voting Rights Act is very costly to bring these court cases.
Oh, yes, absolutely.
A lot of money. And of course, the state or a jurisdiction just taxes everybody and can pay what they want, including the Black people or the Latinx or the Asian or others who are being taxed to support a case that they are fighting that. So that is part of the story that's going on with Booker T. And I mentioned it earlier, but it was pretty dramatic for me to find that Justice Hughes was so important. I'd never been a fan of his.
Yes.
Thought he was a corporate lawyer. And instead, and having gone to Princeton where Woodrow Wilson was almost like a god, despite, we revised his segregating the government thing, and that's probably more in line with what he did with the Southern Democrats and the background that he comes out of. But Hughes really, for the first time, said when the Alabama, or in this case, it was Arkansas, where some African Americans were going to be executed because of supposedly a riot, which in fact the riot was whites killing African Americans. But he says, instead of people like the courts in South Carolina, Alabama, Mississippi, Arkansas, Oklahoma would say, these are race neutral laws. And so they do not discriminate because they don't use the word We are trying to keep blacks off the jury. We are not allowing blacks to vote, but they have to interpret the Constitution as the way that the poll worker says and things. And Hughes said, let's see the evidence.
Yeah.
And that was a big turnaround. The court then started ruling against these state laws and grandfather clauses and things like that, setting up what we think of as that progressive period on race relation, the Warren Court that comes about. And so I've really become really to appreciate Hughes. And it's interesting because for me, as a person of faith, I find it very interesting that the great dissenter, the first Justice Harlan, read that dissent. He says, basically, I'm prejudiced too, but the law says that it has to be equal before people. And he had been a slaveholder, Confederate, and yet he taught a Presbyterian Sunday school class. And I believe that part of that was that idea of fairness that came through. And that's clearly what motivated Justice Hughes, who was a devout American Baptist. And I love the story of when he's Supreme Court Justice and the guard there was where the Supreme Court was, new Supreme Court building, and the guard kept out black people from coming to eat. So he went to Hughes and said, black people trying to come into our restaurant, but I'm not letting them in. And Justice Hughes says, come outside with me a moment. And he turned to him and he said, what does it say over the top of the entrance to this building? He said, equal justice under the law. He said, well, I would suggest that if you cannot enforce equal justice under the law, you should get another job, at which point the restaurant was desegregated in the Supreme Court in Washington, D.C.
Right.
I think that's a powerful metaphor and story of the influence one judge had in terms of turning this court around to look at the evidence. And, I still believe evidence is our savior today. And I love to do this, in the education of Henry Adams, he says that the American mind stood alone in history for the ignorance of his past. But it is his great-great-grandfather, President John Adams, says, facts are stubborn things, and whatever our wishes, our inclination, or the dictates of our passion, we cannot alternate the state of facts and evidence. And I think that's our hope, even in an age of alternative facts, that we as historians we know history's constructed, but like I used to tell my children about the Three Little Pigs story as I'd read it to them, it really matters what you construct your story and the evidence you use for it. And that's what you have to use in the courts. And we saw that with Justice Hughes, and we've seen it again and again. It's worrisome now that some of the justices are not looking at the evidence at all. Very clear in Roe v. Wade how history was misused in the recent Dobbs decision, just the misuse of history and not doing the histories. They aren't, and yet the alternative was there from the American History Association, the evidence to show otherwise. So this is a worrisome time for us with the court, I think.
Well, Professor, I can't think of a better or yet a more, it is worrisome, but it is a better, I can't think of a better way to end this episode than on that note, because one of the things we hope people do with this show is they'll take this new information and go out and do something with it in the public sphere and in the political sphere. So it just remains for me to say thank you so much for coming on the show and talking to us about Justice Deferred. We hope that you'll come back on the show when you have a chance.
I'm happy anytime, and I really appreciate what you do. I want to thank you because I think this is part of the answer to the dilemma that we have is what you're doing to, I really believe there are more of us than there are of them. Younger generations do not want to be prejudiced or unfair. Just look how quickly, gay, lesbian rights and have changed. Who would have thought that quickly? Remember, even President Obama was reluctant to do it. Joe Biden got in front of that, and everyone criticized him, but pretty powerfully, how quickly. And I think that's why we're seeing all these laws now, trying to restrict voting, because people don't want to be unfair. Americans at heart, I think, are good people and they have good hearts.
Yeah.
I'm sorry that they have been so misled in this idea of alternative facts, but I have great faith in the truth. Would you allow me? You don't have to. I'd love to read the last paragraph of the book because I struggle. But
yeah, please. That's a perfect
you
way
can
to wrap
certainly
things up.
cut this if you want to. Okay.
Oh, I don't think I will.
Well, this, I think, speaks to the issue. And while we know that history does not repeat itself, despite me giving these quotes over time and generations,
yeah,
you have to understand how you got to where we are now to make a judgment as to how to go forward because, you know, the past is yesterday and it's going to be the next day as well. So the future comes out of the past. And if we want to help make it a better future, then we really have to understand how we got to where we are as we started with the 12 generations versus 2 generations. So this is the conclusion of the book. In a 1951 poem, the Harlem Renaissance bard Langston Hughes asked, "What happens to a dream deferred?" History, shaped by the court's unfolding interpretations and limitations on rights, tells us that justice has been deferred too long. Abraham Lincoln challenged us, determined that the thing can and shall be done, and then we shall find the way. We take inspiration from the young people who will be writing the next chapter. In 2019, 2020, the U.S. Youth Poet Laureate Amanda Gorman gave readings around the country of a poem she had been commissioned to write for Independence Day. In her performance at the American Academy of Arts and Sciences, Gorman, an African-American woman from Los Angeles who was a student at Harvard, explained that she sees American democracy not as something that's broken, but as something that's unfinished. Rather than falling prey to discouragement, she speaks of being audacious and taking up the mantle of our founders and playing her role in finishing their work. In her poem, Believer's Hymn for the Republic, she declares, "Every day we write the future together." And I think that speaks also when I mentioned Lincoln and his 2 greatest speeches. You know, he talks about the unfinished work. And I think that's what I think that's where we are with the unfinished work of those 13th, 14th, and 15th Amendments to making that Declaration of Independence real in our country that's now in our rule book. And the justices need to understand that and see it. And I have hope that they will.
Well, I have hope that they will too, and I hope our listeners have that same hope. But of course, all that hope needs also to be transferred to the ballot box.
It's a winner take all. It's not a parliamentarian form of government. This is within this extraordinary bipartisan era. It's even, I would say, much worse than the Civil War. And I think democracy's in a crisis, and it's not over with yet.
Yeah.
It really is not. At least in the Civil War, you had Northern Democrats and Southern Democrats, and now it's really become an extraordinary divide. Compromise is so difficult, even when people know it's better for the country to reach an agreement. They would just rather punish the other party than to work together.
Well, thanks again for coming on the show. And we will say to all of you Buzzkillers out there to please go to the Buzzkill bookshelf, where you will find Justice Deferred there, and you can click on it and get it as soon as possible, read it as soon as possible, and we'll talk to all of you out there next time.